Right, let's continue our look at this. We're joined now by Karam Singh. He is with Corruption Watch, the story we have been looking at of this contract. So, Karam, I don't know if you were listening to that conversation we were having, and the MEC says, well, look, our hands are tied. I mean, essentially it means it doesn't matter which administration it is, whether the ANC or the Democratic Alliance. As far as the law is concerned, unless there is a charge, unless there is a criminal matter up against that particular company, or unless it is blacklisted by Treasury, it's fair game for everyone. They can bid.
Yeah, thanks, Thabo. Thanks for having me on the program. I mean, I suppose technically what the MEC and what the Western Cape Premier acknowledged is true, you know, in terms of some of the limitations in the law. The provisions around blacklisting flow in terms of the register of tender defaulters and the restricted suppliers database. You know, the one flows from a judicial process related to the PRECA Act, and we know that there have been very few prosecutions for corruption against companies. But the other is an administrative process, which could meaning that any number of public entities could have put forth royal security on that list as a result of their experience of working with this company. So I think, one of the questions that needs to be asked, not necessarily back to the Western Cape government, but to other entities of state that have worked with royal security, where these allegations of corruption, tender rigging, collusion, and the like have surfaced, and I'm thinking particularly here around PRASA. So why aren't we asking questions back to PRASA about what PRASA has done to follow through on some of the limited findings against them in relationship to dodgy contractors? Yeah. So I think that I do think that the Western Cape government probably didn't do due diligence, because I think if they did appropriate due diligence, even without royal security being restricted, they could have come up with a reason, for why they were not the preferred service provider, given this cloud over royal security. But the fact that they're not, currently blacklisted means that they're free to tender for business with government.
Yeah, but does this not take us to the same almost area as Bain, where Bain says, look, we are a completely different company now. There's new management. We've turned over a new leaf. There's no reason why we shouldn't continue to do business with the state. And similarly, Royal Security saying, well, it's a new ownership. I'm completely new. It's new management. Those allegations have got to do with the old Royal Security, not this new one.
Yeah, I mean, that's something that they can certainly say, and they can also say that there's never been a judicial process against them, and we can ask why there wasn't ever a judicial process against them. I mean, the question of who actually owns this company, I think, is interesting, and it's one of the reasons why we've spoken about issues such as beneficial ownership transparency, because we know that a lot of times people divest from companies, or their names come off the company documents, but ultimately the funds flow to these people or their relatives or people that are close to them. So I don't know that companies can always hide behind something like that, and I think it's fair for the state to say to a Bain or to a Royal Security that given allegations against you, we're going to put you on a black list, or we're going to put you on a watch list or a gray list. And until you, can provide sufficient information that you're a new company, or that you've rectified or there's been consequences for your past ill deeds, that, we're not going to be doing business with you. And I think in that way, the MEC is probably right that there are some deficiencies in the law at the moment in terms of the ease by which, we can blacklist or, suspend certain private sector entities from being able to do business with government. I think we need a more robust regime that makes this something which is easier to do.
Yeah. This, of course, gives critics of the process of the inquiry, like some of us who had asked the question, what is really going to come out of this inquiry after spending R1 billion? And many were saying, well, it's just a pile of allegations and really nothing is actually going to happen. And more, it does seem like all that we got from the Zondo Commission was R1 billion that was spent and a report that is full of allegations, and nobody is really going to be prosecuted and nothing is really going to happen.
Thabo, with all due respect, I wouldn't frame it exactly that way. I think prior to the commission, we were dealing with a pile of allegations. Prior to the commission, we were dealing with investigative journalists. We were dealing with the Gupta leaks. We were dealing with people trying to connect the dots. What the R1 billion got us was an actual forensic report, a forensic report that's supported by reams and reams of testimony, of evidentiary information. We're beyond the realm of allegations now. We actually have a historical record of state capture, of a kind of regime of kleptocracy that was presided over by Jacob Zuma, by the Guptas, by other cronies, some of their cronies who still reside within cabinet. Now, the question of what happens to the findings and recommendations is another question altogether, and that's a question of what's the capacity of our law enforcement system to drive the information that's available to it, converting that into usable evidence that could then be used to have prosecutions, that can then be used to recover assets, that can then be used to blacklist people. That's a weakness in our post-commission system. We needed the commission in order to understand what happened, but we can't blame the commission when law enforcement, when the MPA, when the police are now unable to drive these cases into real accountability. That's a weakness of law enforcement. Yeah. That's not the problem of the commission.
So then would it be correct to say next time the president wants to kick for touch and says, let's have an inquiry, we should ask, well, there's no evidence of you being able to act on the inquiry, so why have the inquiry as opposed to just having the security forces, the police and the criminal justice system investigate and actually prosecute people?
That's a different question, and I think that's a fair question. And I think the issue that I've tried to highlight is that we've got a problem with commissions of inquiry, that they're an insufficient a tool for delivering accountability. We haven't had maybe a little bit. We're seeing it to a certain extent with the Life Esidimeni issue, but very few of the commissions of inquiry that we've had, despite the good work that they've done in establishing a historical record, have been able to deliver justice for us. It wasn't part of the TRC. It wasn't part of the Marikana Commission. So, we need something different than a commission of inquiry. We need a new Commission of Inquiries Act, which similar to the Public Protector finding, makes the findings of those commissions of inquiry binding. So then it would create obligations upon others to act upon them. Or we need something else within our criminal justice system that allows us to go straight from findings and recommendations directly to prosecutions and asset recovery. Something that in law is able to secure the chain of evidence and then move straight to some kind of accountability. But it's fair to say that commissions of inquiry, when it comes to actually delivering on accountability, delivering on justice, have been wholly unsatisfactory.
Does this set maybe some kind of precedence? I hear the MEC saying they've been previously taken to court on this matter and they were found wanting, to say, well, there's no reason why a particular business would not be allowed to bid for work if they qualify and there is no blacklisting and there is no criminal record, they might as well go ahead. But this set precedence for others that would be in that report and recommendations made on them, that they would still say, well, there's nothing preventing us from doing business with the state.
The precedent now would be for the Western Cape government to backtrack and say that we're not going to honor this procurement because of the information that's come to light. there are lots of implicated people, lots of implicated companies out there that have never been found guilty of anything. Not even adverse findings at a commission of inquiry, and they're still tendering for business. And it's convenient for officials not to do due diligence and then let these implicated companies continue to get government contracts. It's not a satisfactory situation for the South African public. I don't think we want to see companies that have benefited for years and years from irregular payments, companies that have kept politicians, former presidents on their payroll, continuing to benefit from the largesse of government. I think that's a wholly unsatisfactory situation. So if the Western Cape government wants to be bold, they would reverse this procurement. They would test that in the courts and say, we're relying upon findings from the Zondo Commission that says this is an implicated company. That was information which we did not evaluate when we awarded the tender, and it's on that basis we're going to withdraw the tender. Let's see. That would be groundbreaking, and that would be courageous from the Western Cape government.
Yeah. Why, if Treasury was able to be bold enough, for example, on Bain to blacklist, have they not gone through that report with a fine-tooth comb and cited a couple of others that need to go under that particular banner?
I think we'd like to see more from Treasury in this regard. I think that, as you say, I think Bain is an example of Treasury taking some action. Of course, they only took action after the UK Parliament, the UK banned Bain. But I think, Treasury also, it's fair for Treasury to come back and say we have a decentralized procurement system, and that we are, we know what's in the Zondo report, but we are somewhat reliant upon government departments to bring information to us. So again, I ask the question, put the question to PROSA. Why hasn't PROSA come forth to Treasury to say, Royal Security was a dodgy service provider to us? There's lots of evidence to support this, and based upon this, we recommend that they be placed on the restricted supplier database. There are other state entities that have alleged to have done irregular contracts with Royal Security. Why haven't any of those companies acted? Why aren't we getting a commission of inquiry into PROSA, as was recommended by the Zondo Commission? We're also in a position where government does control acting upon some of these findings and recommendations from Zondo, and they're not doing it. So, we haven't really fully got to the bottom of what's happening at PROSA. We have PROSA whistleblowers who've been victimized, and, others are getting off without facing further consequences, including, the former CEO, Lucky Montana.
Karam, appreciate your time. Thanks for coming on. That's Karam Singh with Corruption Watch.